Okay, it is about 5 o'clock p.m. Today is Thursday, May the 5th, 2022, and I decided I'd record this a little earlier. As you know that the course is about to end. This is week 6 recording that I am doing, and you know that the course actually ends next Tuesday. So I'm going to take the time to go over the information for week 6. I do want to remind you that it is very important for you to maximize your grades, to make sure that you follow what I say in the lecture, and also make sure that you follow the rubric. I said because, and the module, it's very important. I say it over and over again. And then students ask me how to cite a case. I talked about that before. I provided examples. You know, I said you put the case name, such as Miranda versus Arizona, and then you'll put the case volume, just hypothetically, just showing out 436 US, 489, and then in parentheses, the year, 1966, parentheses. That's an example of how you do it. So you want to make sure that you cite it that way. That's the correct way to cite it. I've said that since the beginning. So I'm going to share my screen, and we're going to get into the module. But first, let's look at the grade book. And of course, you'll see what you have for week number 6. Hudson versus McMillan and the 8th Amendment, your discussion, determining bail, and then your live classroom submission. Here is the calendar. We do the month version. This is where we are today. Your initial post, of course, for this is due on the 10th. And your reply post is also due on the 10th, not the 7th, because this is week 6. And your written assignments are all due on the 10th. The course absolutely ends on the 10th at 11:59 p.m. Central Standard, and unless you have appropriately requested it incomplete, which no one has, and then provide the reasoning then it's best at this point that you text me or call me. Don't email me because we're at the end of time. Okay, remember the course ends Tuesday. All right, let's get to the announcement. Oh, I don't think I've posted the announcement for week 6 yet. I have not. So let's go in. I want to stop sharing. Okay. So let me go in while I'm talking to you and get the announcement in. Give me 1 second. I will have it in a minute. Okay. All right, be right there in just 1 second. You can't see what I'm doing because I'm not sharing it. So give me a second. There we go. Okay, I'm about to put it up for you. Okay, give me a minute. And the course ends. Okay, almost ready. Okay, now let me share my screen for you. Okay, so let's look at week 6 announcement. And here it is. So for this week, the Eighth Amendment and government authority will be presented. Chapter 12, which I'll send you the PowerPoint after I finish this lecture. And the Eighth Amendment dealing with bails, fines, and punishment. Um, and we're going to have you cover the Eighth Amendment, explain it, bail research, cruel and unusual punishment, solitary confinement, and excess and use of force by correction officers. The lecture is taking place today at 7, but I'm doing it a little early. And then remember that your initial post is due on Tuesday and your reply post are due on Tuesday. And your written assignment, Hudson versus McMillan, is also due Tuesday, May 10th at 11:59 p.m. Central Standard Time. Remind you that the term actually ends on May 10th. Take the time to complete the survey, and then you need to finish strong. Okay, so let's close that down and let's get into the module itself. So let's look at the written assignment, Hudson versus McMillan. So this written assignment is examining this landmark case of Hudson versus McMillan. Be sure that you cite the case, the full case. Okay, make sure, not every time, but at the beginning. All right, and then after that, cite it appropriately or APA, but you don't have to have the full official court citation. So you're going to, in a 3 to 5 page paper, remember it's APA, double spaced, okay, citations in the body and references at the end. Summarize the facts of the case. Identify the common factors that a judge would consider when determining Hudson's bail after his initial arrest before trial or sentencing. Describe the factors judges must consider at this time of sentencing. Discuss if force used against Hudson was reasonable or was it unreasonable. Explain why and use the court decision to justify your decision. Then credible sources, APA format, cover page, reference page, professional grammar. Okay. And it should be in the form of a Word document. Okay. Should be in the form of a Word document. Let's look at the rubric. If you don't cite any cases, then you're going to end up over here. You don't want that. So let's look at over here. So you're going to start out with the summary of the case, and you're going to make sure you satisfy these words in here. Factors of bail. You're going to make sure you follow all of the steps in here. Factors for sentencing, once again, and the use of force and credible sources, okay? Very important. That means citations in the body, okay, including a reference page. And then 3 to 5 pages. So if you do everything up here and you don't have at least 3 pages, you're going to end up over here, okay? So you want to make sure you follow that. Use the official court citations. All right. Bail for the discussion assignment. Remember, the Eighth Amendment deals with reasonable bail. So you're going to apply the Eighth Amendment to this scenario. And then in your initial post, discuss the factors that you must consider when determining bail, and use the Bail Reform Act as your guide, and what other information might be needed to make a bail decision. Apply the standards of the Bail Reform Act to Jim's background. And then what would your decision be related to bail? Locate an actual story or case or a practical example to support your decision. What has bail been for previous offenders? And then apply to one other post. Remember, these are due by Tuesday. And then your live classroom session, you put the phrase that I'm going to give you, and then you're going to have the link that, as you know, you click here. This will not be it. It will be changed to week 6. All right. And then I'll email you the link. So we're going to talk about these items here. All right. So let's start by talking about bail and its limitations. So as I said at the outset, that bail is a constitutional right that the Eighth Amendment says. It says excessive bail should not be required, nor excessive fines or cruel, unusual punishment. So the bail should be based upon the offense, and one point the judge considers. Another is the individual's criminal history as well. And we're going to talk about those points in this lesson, okay? And then we're going to talk about cruel and unusual punishment as well, okay? Now, one of the issues that people think about in terms of bail is individuals who can't afford bail, even if it's a reasonable bail. Then there are questions that we want to make sure that bail does not, as it says, disproportionately affect individuals who are poor. And as a result, jail overcrowding can exist. People can lose their jobs, their homes, and custody of their children. And so the key issue for bail, number one, is to guarantee the defendant's appearance at court. That's the key. That is the key thing. And the Eighth Amendment, as I said, addresses that specific. All right. So let's talk about bail and its limitations. So the Eighth Amendment doesn't actually give any guidelines about what is excessive. And so what we do is we look at it on the basis of cases, going back to Stack versus Boyle, which indicates possibly what excessive bail is. So here's an example. In Stack, 12 defendants were arrested for violating the Smith Act, a law that outlawed attempts to advocate, abet, advise, or teach government violence destruction, or government violent destruction. The court set the bail at $50,000 each of these individuals and didn't provide any evidence as to why they did it. So the court said that the defendants should be able to have bail consider methods to make sure it's not excessive but reasonable. And some of the things that here's some things you need to remember for your written assignment today. Arbitrary bail is not acceptable. So that's what they did in the Stack case. Bail must be based upon standards relevant to the purpose of assuring the defendant's presence, which I said, or attendance to court, and then to be done at a bail hearing. And usually that's 24 to 48 hours after a person is arrested as well. Requests to reduce bail are considered at that hearing at that time, okay? So you got an understanding that one of the key factors to consider is that the bail be reasonable, is the offense, the history of the individual, as well as a commensurate amount that would probably guarantee the person appearing for trial. In some instances, you're going to hear about me talking about an I bond. That's a bond where a person is released on their what we call recognizance. Those are usually granted to individuals who don't present a major threat to the community. They're not considered as violent offenders. And so as a result, those individuals will find themselves where they're able to operate in the community. They're not a threat to community, and that they're not likely to commit offenses while they're out. Okay. So, common types of bail, as I said, you have cash bail, I bonds, which is signature bonds, or property bonds, where people pledge property. And the documents for bond have the various options, and then there's a bond appearance form here. If you click on it, then you can see it. I'm not going to open it up. Now, when there is a bond, usually if the bail is $50,000, usually it is required that the individual posts 10% to get out on bail. Okay, that's for a cash bail. A signature bond just requires the defendant to acknowledge that they will appear in court and comply with all the conditions of bond. So if the bond sets out conditions like don't carry weapons, don't hang around criminals or individuals who've been convicted, and of course don't commit any crimes. Okay. A property bond is a secured bond, and collateral such as titles to property or and sometimes even titles to vehicles. And if you fail to comply with the conditions, the forfeiture of the cash, which is posted if it's a cash, or the collateral, whatever that is, whether it's real or personal property. Failing to appear in a future court appearance also results in an arrest warrant being issued. So it's important that people understand that bail is important. It allows individuals not to be incarcerated during the time that they're awaiting trial. Okay. As I said, it must fit the crime and consider the factors that we've discussed. All right. By the way, the citation for Stack versus Boyle is 342 U.S. number 1, 1951. Okay, so that's how you properly cite the cases. So let's talk about the Bail Reform Act of 1984. And we just go over this a little bit. Now, in Stack, as I said early, it did not give specifics about what would be excessive. But remember, as it said, the intent of bail is not to limit preventing flight or safeguarding the role of guilt or innocence, as it says in the United States versus Salerno. But bail can be used to hold dangerous criminals, individuals who might be a threat to the community. But the Bail Reform Act identified factors to be considered when making bail decisions. So let's take a look at these 5 points. The nature and seriousness of the charges, as I mentioned that earlier. The weight of the evidence against the defendant. So they consider the type of evidence that's been already presented preliminarily. The background of the individual, their characteristics, length of residential ties to the community, their history of drug or alcohol abuse, prior criminal history, as I said, and court appearances, prior court appearances as well. If the defendant was on probation at the time of the offense, bail might be a little higher than the individual. If they're not, then it probably would be lower. So in other words, what they recognize in terms of setting bail is, did you have a chance to stay out of jail, to stay out of trouble before? If you were placed on probation, or if you're on parole at the time, or what we call on paper, then chances are your bail is going to be higher because of the circumstances. And finally, the nature and seriousness of the danger to the community. So if a person is a person that would probably be violent or likely to create violence in the community, then they may not be released on bail. And a lot of times that happens in situations where people commit murders, even though that there is bail in those situations, but it depends on the circumstances that are involved. Okay. All right. So that's how that works. All right. Now let's go to the sentencing and cruel and unusual punishment, since you've got bail down. Remember, they both are based on the 8th Amendment. So the situation that occurs oftentimes is to determine if the sentence is excessive. So this fact pattern that's given here about 16-year-old, father was abusive, alcohol, hung with the wrong crowd, committed a robbery, a burglary, and killed the clerk, and John was arrested a few months later and charged with armed robbery and felony murder. And so the pretrial process, which it took a little while, and he was not convicted until his 18th birthday. So what type of sentence might John face? First thing you should be aware of is that John, being a minor, would not be executed because the law has determined that we do not execute juveniles. And the leading case for that is, give me a second, I will pull it out. Okay. All right, give me a minute here. Okay, here we go. Okay. Okay. In 2005, in the um, Roper versus Simmons case, 543 U.S. 551, the Supreme Court held that it is unconstitutional to impose capital punishment for crimes committed while under the age of 18. And that's the way it is right now. So, because the offense was committed before he turned 18, could he receive a life sentence? Possibly. Um, and the factors that should be taken into consideration when sentencing John, we'll talk about that in a minute. And the judge must ensure that the sentence imposed does not represent a violation of the Eighth Amendment. So we're gonna look at these already. All right. So we already know that it prohibits cruel and unusual punishment. All right. And so let's take a look at what does that mean. So it is here, as we talk about, that um, cruel, unusual punishment, where the United States Supreme Court has, first of all, number one, approved the death penalty. That was in 1972, way back, long time ago, um, uh, 51 years ago, and Furman versus Georgia. And what they did was it was determined that the death penalty was applied in an arbitrary and discriminatory manner. And so the poor was deemed to be affected. And so at least two justices concluded that the death penalty as a whole was cruel and unusual punishment. So what they did was they set standards out for the death penalty. And 4 years later, though, in the Gregg case, the court said the death penalty was not cruel and unusual punishment. So in the Furman versus Georgia, and approved the death penalty. So it was approved, but in 76, the Gregg case said nope, it is not cruel and unusual punishment, and it recognized that it could be a means of deterrence and retribution, which we disagree with, those of us who are in practice, because the death penalty does not represent a deterrent effect except on that one individual. So Gregg overturned Furman versus Georgia and made changes to the standards, which basically set it out the way it is today. So the death penalty is legal in 28 states and unlawful in 22 states, which means it was banned and done away with. I do know states, so Wisconsin don't have one, and Illinois. We had one up until, I believe it was 2013 or 14 when it was done away with. And so if there is a desire to use the death penalty in the states, and it is a juvenile, then you can't do it based upon Roper versus Simmons. I just mentioned that to you a few minutes ago. All right. So you should have that understanding. So the death penalty itself does not violate the Eighth Amendment, but there are certain standards that are applicable. And when you look at the understanding that it takes a long time when individuals are placed on death row before they could finally end up being executed. So when the court hands down sentences, they can't arbitrarily hand down sentences without providing rationale. And so in the Solemn versus Helm case, the court said that the importance of principle proportionality must be recognized in American jurisprudence. And what that means is the punishment must fit the crime itself. All right. And so here are some factors that are considered: the gravity of the offense and the harshness that the penalty would represent, sentence imposed on other criminals in the same jurisdiction, whether more serious or subject to the same penalty, and then finally the sentence imposed for the commission of the same crime in other jurisdictions. So in other words, the court looks to see how, for the type of crime a person commits, the sentences might be, starting in their jurisdictions, and some might consider other jurisdictions as well. And by the way, these are the official court case citations for the cases that some of them I mentioned. All right. So here's some Supreme Court examples, and it gives Robinson versus California. I'm familiar with that one, where he was sentenced to 3 months for violating a law that prohibited people from being narcotic addicts. Well, the court says addiction is an illness, which I agree with that. And imprisoning people who are sick is cruel and unusual punishment. Punishing someone because of their status, that is being an addict, is unconstitutional. And it makes a whole lot of sense because what needs to be done, as I've said this in teaching corrections and drugs and crime, that individuals need to get some help for their problem, and that locking them up does not solve the problem, and it just stays the actions that they might do, so that when they get out, they'll commit more crime if the issue is not addressed. In Lockyer versus Andrade, a 2003 case, the Supreme Court determined if the habitual offender or 3 strikes law, which resulted in 25 years to a life sentence, was appropriate for stealing $150 worth of videotapes. I think on its face, you can see that that would probably be considered as cruel and unusual punishment. So the court agreed and said that described the penalty as a rare sentence of demonstrable gross disproportionality. Yeah, so in other words, the crime that was being charged did not justify it. 25 years? Wow, that's ridiculous. So you have to think about some common sense that is involved in sentencing. We, in our jurisdiction, have what we call mitigating circumstances that prosecution usually brings out at sentencing to determine how the person should be sentenced. And that, mitigating is what the defense brings out to hopefully help the individual get a lighter sentence. Aggregating circumstances is what the prosecution brings out, and that makes it so that the individual receives a higher sentence because the offense is more egregious. So in Graham versus Florida, a 2010 case, the court took a look at to see if sentencing of a juvenile offender to life for armed robbery was cruel and unusual punishment. The majority applied the proportionality test and concluded that life sentences of a juvenile who commit non-homicidal offenses have been rejected the world over, and that juveniles should be allowed to atone for their bad decisions and have an opportunity to leave. So therefore, unless it's a homicide involved, someone dies, then in that case, you cannot issue a life sentence. And that makes sense. Okay. All right. So that's pretty much it for here in terms of the death penalty. as well. Okay. Cruel and unusual punishment after sentencing. So, as I already talked about, the Eighth Amendment prevents cruel and unusual punishment um, and application of death sentences. Although the courts have never affirmed one death penalty method over another, they have certain methods that are barbaric, such as hanging. Um, and so you're going to see as we go over that in this section, this section. So cruel and unusual punishment within prison or jails applies to prisoners that are in the facilities themselves. And so when the inmates are treated while they're in the facility, um, um, an individual cannot be excessively punishment. For example, if a prison guard could ignore an inmate's serious injury or illness, that would be considered as cruel and unusual punishment based on Estelle versus Gamble, or failing to provide mental health treatment for individuals who have severe mental illness. It says when overcrowding prevents inmates from receiving adequate care or treatment, a minimal standard of living ordering the release of a certain percentage is constitutional, and that happens a lot to relieve overcrowding. Okay. If a serious injury or illness is inflicted by a prison guard, such as excessive force, using unnecessary beatings, handcuffing, or hitching an inmate to a mounted latch, taunting them, denying bathroom breaks. This would be a violation of the Eighth Amendment based on Hope versus uh, Pelzer. If you pay close attention, what it really requires is humane treatment by the individuals. Prison guards are permitted to use reasonable force to restore order. However, though, maliciously punishing prisoners, regardless of injury sustained, would be unlawful. That's Hudson versus McMillan, which you well know about because that's the case that is involved in your written assignment. When force is used, the correction officers have to make sure they justify that force. Okay. And then, by the way, there is the citation again for Hudson versus McMillan. So you have it again. So you have already learned and discovered that the death penalty on its face is not cruel and unusual punishment. But as I said, the way that individuals are executed, lethal injection, execution, and the firing squad have been considered as constitutional. But it's not used very much in America. Death by hanging was not deemed cruel and unusual, but the death penalty cannot be carried out in barbaric means. And so the key thing is like ripping limbs from the body and things like that nature, public dissection, burning alive. In addition, I think, quite honestly, that hanging is one that should be considered as cruel and unusual punishment because the person is tortured. Lethal injection might be one of the most humane ones. Death by electrocution, it's kind of in the middle there. Okay. So death penalty is very controversial, but what has happened pretty much is that the states themselves have been pretty much able to decide whether or not there's a death penalty in their jurisdictions. All right. And then this is something you can study on your own, but I'm just bringing it up for you. The decision making. The question is the subject verbally or physically resisting lawful authority? Is the subject attacking, making attacks that are not likely to cause death or great bodily harm? And then is the subject uh, making attack movements that are likely to cause death? And so as a result, the factors are what are the physical size, the weapons involved, demeanor of the individuals, and other things. What officer factors include the training that you'll have and receive, and experiences, physical size of the individual, and others. Okay, and then you deal with officer's response. Can you physically control the subject without um, putting them in danger of losing their life, such as the George Floyd situation, which was determined that it was excessive? Could you use non-lethal weapons not meant to cause death? Depends. Is a deadly force the appropriate method or option to prevent death or great bodily harm? And then finally, the justification that exists. All right. So those are just some of the things that you would be considering. So finally, the knowledge check. This is something that you can study yourself for information. And which amendment prohibits cruel and unusual punishment? Everybody should know this one. That's the 8th. That's correct. The 8th Amendment. Which factors must be considered by a judge when making a bail decision? The nature and seriousness of the charges, background risk to the community, nature and seriousness of the charges and the victim's background, the nature and seriousness of the charges at the time of the offense, the weight of evidence and veracity. Which factors? So it should be the nature and seriousness of the charges, the background, and the risk to the community. Let's try that one. That is right. Bail decisions do not typically involve consideration for the background, but the veracity of the witness or at the of the time of the offense. And then you can go on and you can check. This is the last one. Which Supreme Court said it was cruel and unusual punishment to sentence someone who is merely an addict? Roper versus Simmons. Hope you don't pick that one. Is it Robinson versus California? Is it Solemn versus Helm? Or is it Gregg versus California? I hope you don't pick that one, but I do hope you pick this one. Okay, so you go over that. Okay, good people, that's it for me. I hope that you've learned a lot in constitutional law. By the way, the key is the 8th Amendment. Just give me 8th Amendment. You can write it out or you can give me the number, 8th Amendment, and you get your points. So I hope you learned in this constitutional law class. I hope that you enjoyed it. I enjoyed teaching it because the constitutional law classes are kind of like my bread and butter. I got a degree in political science, and then I practiced criminal law many years. And so it's something that is very important for all of us to understand the rights. I also had to deal with it when I was a law enforcement officer as well. So I hope each and every one of you will do well, continue to be successful in your endeavors. I will be teaching this course again starting Wednesday in term 2. So if you didn't pass this class, which I don't think I have very many, most of you did pretty well. But just remember what I said about the rubrics. People always want to know, well, if I lose only I should lose only a few points because I didn't cite the case appropriately. Well, the rubric says if you don't cite the case to support your statements, you belong in the last category. The reason why we do that is not to be picky, but to get you into the habit of following the directions of the assignment and to understand that in order to maximize your grades, then you want to make sure that you follow the assignment rubric, what I say in the lectures, and also what's in the module. Usually in the module, it gives you the answer. The rubric certainly does, and I elaborate on it during the lectures. All right, so enjoy the rest of your evening and get those assignments in. All right, if you have any questions at this juncture, it's probably better to text me and email me because the course is about to end. So have a good evening.